Right, Mr. Machulak, please proceed on behalf of the claimants.
Thank you very much, sir. Mr. President, members of the Tribunal, again, my name is John Makalak, and I'll be speaking right at the beginning to give you some background to what has happened and leave the legal and I will Professor Newcomb will be addressing you with the more legal portion of the argument. First, let me say this. We do represent two claimants, Commerce Group Corp. And San Sebastian Gold Mines, Inc. They are separate companies, and our duties lie to two clients. They are very close in terms of the number of shareholders, but there are different sets of shareholders to the two of them. Let me say first that Commerce Group Corporation is a Delaware corporation incorporated in 1962. It's now been converted into a Wisconsin corporation along the way. San Sebastian Gold Mines, Inc. Was founded as a Nevada company in 1968. Combined, there's about 3,300 shareholders to the two corporations. You've been presented some facts, the joint venture agreement. Let me give you a little bit of background on that. This project in El Salvador, where the two have been mining and processing gold, started in 1968 with an investment on the part of San Sebastian Gold Mines, Inc. Commerce became a shareholder of San Sebastian between 1968 and 1978. It had that status. San Sebastian was kind of the lead. The Civil War broke out in 1978, or at least was at a stage where we couldn't mine anymore in El Salvador, and work down there discontinued in 1985 when the two companies came back to El Salvador. The whole operation, the mill and plant that had been there at the time at the San Sebastian gold mine were destroyed or just missing, and we were starting from ground zero at that point. So at that point in time, Commerce began to give a more heavy investment in San Sebastian Gold Mines, Inc., and eventually it was supporting a rekindling of the operation in El Salvador. In 1987, if you recall from the materials, is when President Duarte awarded us a new concession for exploitation at the San Sebastian gold mine, and Commerce was more involved in getting the financing to get that going. At that point in time, the parties entered into a joint venture agreement. And the big contribution that San Sebastian had at that time is they had the lease rights to the mining site down in El Salvador. And basically, I'm reciting to you the very same background that you'll see in the joint venture agreement itself. After the 1987 concession was granted, the company acquired a new mill about 15 miles away from the original San Sebastian site, rather than attempting to rebuild on site, because there had been a Canadian Javelin mill there that was available. That became the San Cristobal mill, and from that took a considerable amount of refurbishing, but from 1995 through 2000, the companies were producing gold at 22,700 odd ounces of bullion at the San Cristobal. The ore was taken from San Sebastian and carted over there. And eventually, after about 5 years of production, successful production, the company was going to expand the mill site. In between 2000 and all the way through 2004, and earlier, the company had a remarkably good relationship, we thought, with the country of El Salvador. There's mention in the materials about us getting a new concession, which happened in 2002. The company adopted a new mining law. We adapted. We took our concession. We got we worked with the government to get a not only a long-term concession for the San Sebastian gold mines, but we got two other exploration sites at that time that consisted of another 86 kilometers in the vicinity of the mine site. And last but not least, all the way through this long history with El Salvador, the company has had a mining presence. It's invested in local infrastructure, built a church there, roads, bridges, created hundreds of jobs there, and it contributed. This was not an operation that that just took without giving back. Now, what happened? What led then to the CAFTA filing? Well, at the point in time, everything started to come to a head in 2006, or the start of the problem. At that point in time, the company had a concession through 2034 for the mining site. It had 86 square kilometers in its exploration concession. It had a substantial investment that went all the way back to its first involvement in the gold mine. What happened in 2006, not only was the revocation of the environmental permits that we talked about, but the exploration was denied. The exploration was not renewed, and the important thing is that in 2006 there was a de facto moratorium on mining. I mean, it's clear. We've given you information in the materials about just a glimpse of some of the newspaper articles. In mid-2006, in July 2006, there was an announced de facto ban on mining. In fact, the article that we put to you shows that it wasn't that it was something the minister said. There's not something that we did. It's something that generally the country is going to go through, is not going to issue mining permits for anyone. And this was 2006. This was just ahead of the government taking action against us to tell us we could mine or explore no more. That continued.
Could you please speak in the microphone, unless you want to?
Sorry.
Otherwise, because otherwise it's not being taped properly. Otherwise, you can be provided a roving mic if you want to have that.
I'll try to be good.
No. Everybody has his own style of presentation. If you would like to have one, we can provide you one.
Yes.
If you have one, that'd be great.
Okay, because
I'll try to stay right here until you're ready for that. But yes, you know, we'll come to that, but we did start in a proceeding, a challenge in the administrative courts of El Salvador in 2006. In 2007, we asked for an injunctive relief to continue mining during the case, and that was denied to us by the El Salvadoran court. There's a lot of discussion in the materials about how everybody is waiting on the ruling of the court. Quite frankly, they're really, at the point in time we got to the CAFTA proceeding, there wasn't really a lot of hope in the outcome for the court there, although we thought we had a strong case. In 2000, all the way along the way, 2008, 2009, and 2010, the government of El Salvador continually told everyone that there would no longer be permits issued for mining. In 2000, and what led to the CAFTA proceeding specifically? First, in 2008, Pacific Rim, another mining company that perhaps you're familiar with, has a similar dispute with El Salvador, announced its intent to file for arbitration. We as a team, this team, a different team, went down to El Salvador in February of 2009 and said, can we work with you? Is there some way we can work this out? And we were very interested in doing so because we had an investor from the previous year who was having trouble with working with the El Salvadoran government to be able to kind of take over the operation and get it going. There's a missing fact here in 2007, my dad, who is like the spearhead of the whole thing all the way along the way, passed away. And we were looking at outside investors to come in and assist us with the mining. We then, in a very dramatic way, found that the government was not going to give us any mining permits because it didn't matter how much money you would invest, what you would do at the site, there'd be no mining in El Salvador. I found that out myself. I found that out myself in meetings with the Ministry of Environment, with the Council for the Ministry of Environment, where we announced that this is what's going to be coming. In March of, then finally, in March of 2009, we gave our notice of intent to file for a proceeding under CAFTA. One of the things that was paramount in our mind was a lot of this action took place in 2006. So it was kind of time the fisher cut bait in early 2009 when we finally put out our notice of intent. Now the thought being projected by the respondents is that in 2006 we commenced this litigation, and 2009 the Supreme Court began its deliberations. We did not know that at the time. If you look at the documents being submitted to you, we understood that this was a proceeding that was off there somewhere in the distance, but it was out there. Obviously, we referenced it in our arbitration proceedings. When we started our arbitration proceedings, which was pretty close to 90 days after our notice of intent, I have a timetable here that would be helpful in the thing, but here let me just walk you, if I may, through the documents. On March 16, 2009, we gave our notice of intent. On July 2, 2009, we submitted our notice of arbitration. With our notice of arbitration, we submitted 2 waivers. One was a waiver by Commerce Group Corp, which you have as an exhibit, and one is a waiver by San Sebastian Gold Mines, Inc. These were both dated the same day, signed by my brother, who is now president of both companies. Next, well, I will say this, there's talk about us purposefully delaying the CAFTA proceedings. When we filed these 2 waivers, we thought we thought we had done we read the treaty and we thought we had done everything that complied with the treaty, because we filed it religiously in framing the waivers. And we did not understand and did not agree, or just didn't understand at this point in time, that you had to do anything else but give the waiver. And to us, a waiver means the other side can do with it whatever they want to. But you have no right to claim $100 million, $111 million. You're done with whatever you want to claim later. And what started to delay things, you can see right in our petition, and count this as our experience, but I have 2 pages of the last 2 pages of our notice of arbitration. My brother and I, when we started the thing, we went through the list provided by ICSID, and we picked Professor Greenwood out of the list as an arbitrator. And we had not talked to him, we had not spoken with him. We just understood the proceeding. You go through the list and pick one, which is what we did. We did not know that he was unavailable, or you go through this process of finding out whether people are available before doing it. But this is what we did on July 2nd. We picked Professor Greenwood. Then, after we filed, we got a letter back from ICSID asking us questions about our filing. This was and we responded to that on August 19th, which is in the exhibits furnished by the respondent. But what the respondent says is that on August 14, 2009, the Attorney General for El Salvador writes in, and we didn't so much as respond to it. Well, truthfully, we weren't sent the letter. This letter was filed ex parte with ICSID, and the way we found out about it was a little bit later. I think that my emails with the ICSID will confirm that. But what happened is that when Mr. Smith wrote to us on August 24, he referenced a letter to the Attorney General, but it was not It was not a letter that was addressed or where we were copied. Now, when we studied, the exhibits I have for you has some yellow highlighting, which is not exactly coming up on the overhead screen. But here's how we interpreted the letter from the Attorney General when we got it. We asked for it and we got it. In the second paragraph here, where I've got the highlighting in your thing, the Attorney General said, even if claimants were to withdraw the legal proceedings still pending in El Salvador, claimants' failure to honor their waivers before submitting the request for arbitration to ICSID cannot be remedied once the request for arbitration has been filed. So we're looking at this from our practical standpoint. Here we are in August of 2009. We certainly don't want to get into a statute of limitations question. This is 3 years after, what they're saying is you have to dismiss your CAFTA proceeding and then go through some process in El Salvador before you can even, of unknown time frame, before you can start it. I mean, this is something that the position that they took at the time. It wasn't let's continue this now. It says you have to dismiss the CAFTA proceeding before you do anything else. As you go to the very last line of this page, it picks up on the next page. They go on to say there, the defects on the request for arbitration are not of the nature that can be cured once the request for arbitration has been filed. So it isn't asking us to do anything now. It's saying you're basically, there's nothing you can do right now. There was never any request to do something vis-a-vis the domestic proceedings. It's basically saying dismiss the CAFTA, otherwise you will forever have this jurisdictional defect. So what was happening at the same time for us? In the next exhibit, you see we had a letter, and this was referenced from doing the buff from Mr. Derek Smith. But this letter basically reiterates the same thing. If you go to the, told us the same thing, and it said that, the second paragraph, that claimants have been made fully aware during the registration process through the letter of the Attorney General to the Secretary General, through the letter of the Attorney General to the Secretary General, together with claimants' knowledge about the nature of proceedings, that they did not comply with the jurisdictional requirements. We read this, and it really doesn't say that we got it doesn't say we got this letter, but we read this, did we comply with the jurisdictional requirements? We go back to look at the treaty, and in our estimation, we have. And you look in the very next paragraph, it's still, we have, the second middle line there, we still have the choice to request discontinuance of the arbitration. That was the drive at that point in time, that we were jurisdictionally defective from the beginning, that there's nothing we could do to fix it. Now, and in the second page, they reiterate the same point. So it's not to shortchange Professor Newcomb. Let me just say this. It took some time, and you have the exhibits there to sort through for us to get a replacement arbitrator appointed after Professor Greenwood. We wrote him, and he said he is not available to do it. So, that delayed some proceedings on our part. never in our part did we say this whole fiction of waiting for El Salvador is so outside of what was going on there. It's incredible to me. But if you look through the proceedings here, you will see that there was a lot of things happening vis-a-vis for us versus ICSID, and we were trying to do what we could to advance the proceeding forward. A couple of other exhibits I want to mention. One is that the El Salvador submits a kind of a status report from their Attorney General, and what that status report says, working with the translation, is that at some point, and this was right around when the Attorney General wrote ICSID, he asked for a status report of the local proceedings. And the clerk, this is just a request for a status report, and the turnaround is not a day or two. I mean, it's just to get a status report from the court takes a considerable turnaround in time, and this is nothing of a procedural nature happening in the El Salvador case. The other thing I wish to point out from their exhibits is that they submit a letter and translation from Pedro Valle, one of our attorneys in El Salvador, who is not the one who is involved in the local proceedings, but he contrary to being hopeful about something happening in El Salvador at the time, his letter shows that after we filed our CAFTA proceedings, we started to disassemble the mill and plant, and we were certainly not. The letter does not bespeak some wonderful expectation of something that's going to happen in a month or two. I mean, we were closing up shop down there, and more to the point, he says we're complying with whatever they want in the resolution that in the government action that we were challenging in 2006. I highlighted the section there, and I know you do not have a full translation of what things will discontinue an administered proceeding before you, but I understand that in addition to 40B, which says the claimant can submit a withdrawal, there's a subsection C there that says if you start to act in conformity with the government action you're challenging, that's another grounds for dismissal. How these things all play out procedurally, I couldn't tell. I do not have the type of expertise, I'm sure, that the Attorney General of El Salvador has, but I know that none of this is directed to somehow perpetrating or prolonging the CAFTA proceeding. So without further ado, I'll give you Professor Newcomb.
Thank you. Professor Newcomb, please proceed.
Mr. President, members of the tribunal, representatives of El Salvador, representative of the CAFTA parties. Mr. Matchlick has outlined the context of the dispute and the proceedings to date. My presentation will focus on the overview of the claimant's submissions with respect to the preliminary objection. I will be making 6 principal submissions in response to the respondent's preliminary objection. First, the claimants have fully satisfied the jurisdictional requirement under CAFTA Article 1018.2 with respect to the submission of waivers. In light of the parties' agreement that the claimants' waivers satisfy all formal requirements, the narrow issue for determination is this question of whether a CAFTA claimant is required to request termination of a domestic proceeding as a jurisdictional precondition prior to a claim being submitted to arbitration under CAFTA. The claimant's answer is a clear no. CAFTA Article 1018.2 imposes no such requirement, and to interpret Article 1018.2 in such a way would be to read in a restrictive jurisdictional precondition that is not present in the plain text of the treaty. My second submission is that the claimants submit that the continuation of the domestic proceedings after the submission of the notice of arbitration is a question of admissibility of claims, not jurisdiction. Although the claimants affirm that this tribunal has the power to find that claims are inadmissible where there are concurrent proceedings, we submit that there is no impediment to the admissibility of claims in this case because there never were concurrent proceedings. Further, there are no ongoing current proceedings that could serve as an impediment to the claimant's claims. My third submission is that since July 2nd, 2009, the date of the submission of the notice of arbitration, the claimants have acted consistently with the waivers and in good faith. Fourth, if this tribunal were to find that the continuation of the domestic proceedings with respect to the revocation of the environmental permits affects in some way the tribunal's jurisdiction, the claimant's submission is that any impediment exists only to the extent of the overlap of the measures between this proceeding and the domestic proceeding. In particular, the measure in question in the domestic proceedings, the revocation of the environmental permits. Claimants' other claims in this proceeding with respect to other measures, including the respondent's treatment of the exploration licenses and the respondent's de facto moratorium on mining, which continues to this day, are unaffected as these measures were not the subject of the domestic proceedings. Fifth, any jurisdictional impediment that may exist applies only to the Commerce Group and not to San Sebastian. Sixth, and finally, the preliminary objection does not apply to the claimant's independent claims for breach of the foreign investment law. Even if accepted in its entirety, the preliminary objection does not apply, actually does not even raise the issue of El Salvador's consent under the foreign investment law. Now, I understand this morning the respondent has raised the issue of the respondent's consent under the foreign investment law and also the claimant's consent. I would suggest that this issue has not been briefed. The preliminary objection was a preliminary objection to whether there was consent under CAFTA. So I think that there's a question of whether in the tribunal's decision that arises out of this preliminary objection, whether the foreign investment law, to what extent the foreign investment law issue it really is before the tribunal in this preliminary objection. To the extent I can, I will try to be responsive to the claimants. I will try to be responsive to the respondents' arguments this morning, although many of the points I will have to elaborate on this afternoon.
Sure. But perhaps then you may also consider the following question in relation to the invocation of the investment law, which is the text of the waiver itself. The text of the waiver refers to any right to initiate or continue before any administrative tribunal or court under the law of any party or dispute settlement procedures, any proceeding with respect to measures. Does the investment law, the arbitration contemplated by the investment law, fall under this waiver provision?
No, it doesn't, Mr. President. As in the PAC RIM case, which decided this particular issue, the waiver, this proceeding, this arbitration is not another. I don't have the provision in front of me now, the 1018.2. The point which I will...
Perhaps you would like to take it...
I'll return to this afternoon is that it's not applicable.
No, you would like to take the text in front of you.
Thank you, Mr. President. The waiver provision requires a waiver with respect to or other dispute settlement procedures, any proceeding. Our submission is that there's one arbitration and one proceeding. There are claims that are submitted under CAFTA, under the consent of CAFTA, and under the consent of the foreign investment law, and that this tribunal is not an or other dispute settlement procedure.
So what we have is a 1 in 2 or 2 in 1? What do we have here?
We have claims arising from two different instruments, one treaty, one foreign investment law, with two separate consents to arbitration in one proceeding, in one arbitration. And as determined, we would submit that the preliminary decision in the PACRIM case, which decided this particular point, as we submitted in our pleadings, decided that the waiver did not exclude the tribunals, does not apply where claims are brought into one proceeding.
Thank you.
Turning to my first submission, Commerce and SAMSEB submitted written waivers as required by CAFTA Article 10.18.2 with their notice of arbitration. Mr. Smith has indicated this morning a number of areas of agreement between the parties. I won't go into those in detail, other than to note that the respondent has not raised any objections based on the form of waivers submitted by the claimants. In its pleadings, the respondent has not disputed that the waivers were effective to waive the claimant's rights in the domestic proceedings. In the respondent's preliminary objection at paragraph 21, the respondent states, claimants therefore knowingly and willingly waived any right to initiate or continue any proceeding. The respondent's reply at paragraph 3 states that the parties agree on several points. Pursuant to the waiver, and I quote, they, the claimants, waived the right to continue the domestic judicial proceedings. Although the respondent argues that the claimants were required to take additional steps when it was submitting the claims, in particular to request discontinuance of the domestic proceedings as a precondition, respondent has not contested that the waivers were, in fact, effective to waive the claimant's rights to continue the domestic proceedings. Claimants say that the waiver was defective for purposes of CAFTA jurisdiction because of the failure to request the discontinuance, because they read in this jurisdictional precondition. They have not contested that claimants' submission of the waivers had a legal effect. The waivers waived real legal rights, and the respondent was the beneficiary of those waivers. The respondent simply ignores this fact and argues that the treaty required more, a submission, as I will, that is without legal merit. Fourth, the parties agree, my next point is that the parties agree that the jurisdiction of this tribunal is determined as of the date of the notice of arbitration, the date that's received by the Secretary General, and that events after that date do not affect jurisdiction. As a result, in the claimant's submission, conduct after the submission of the waivers, which I will refer to for ease of reference as post-waiver conduct, is not relevant to whether this tribunal has jurisdiction. Jurisdiction can neither be lost nor found by events occurring after the submission of the notice of arbitration. Now, there is a difference between the parties on the date for determining jurisdiction. The parties agree that Article 10.16.4 governs, and the notice of arbitration is deemed to be submitted when it's received by the Secretary General of ICSID. Claimants submit that the date of receipt of notice of arbitration was July 2nd, 2009. The date that the claimants the date of the claimant's consent to arbitration and the date that the notice of arbitration was emailed to the Secretary General. The respondent submits that the date of receipt is July 6th, the date of the Secretary General's formal acknowledgement of receipt. I would like to explain why the claimants take this position. The Marne resolutions, the Ministry of Environment resolutions revoking the environmental permits, are dated July 5th and 6th, 2006. But it's clear from the record that the resolutions were notified to the parties on September 13th, 2006. And this is the position that's taken by both parties and supported by all of the evidence, all of the exhibits. The 3-year time limitation for bringing a claim under Article 1018(1) with respect to the revocation of environmental permits runs from the date of knowledge of the event, and thus runs from September 13th, 2006. So we submit that since the notice of arbitration was received on July the 2nd, 2009, there can be no question of the 3-year time limit running. But out of an abundance of caution, we submit that the earlier date, the July 2nd date, applies in order to ensure that the respondent does not later opportunistically change its position and make a further jurisdictional objection that the 3-year time limit applies on the earlier date of the date of the resolutions revoking the permits, which were 5th and 6th July. Thus, if the date of receipt is July 6th, there may be a potential for a further preliminary objection. So that's the sort of the reason, the rationale why we submit that July 2nd is the date for determining jurisdiction. I now turn to my primary submission, primary dispute between the parties. Were the claimants required under Article 1018(2) to request discontinuance of the domestic proceedings prior to submitting a notice of claim? This is fundamentally a question of treaty interpretation. The interpretation proposed by the respondent reads in a jurisdictional precondition in Article 1018(2) that does not exist in the text of the treaty. It's well accepted in international law that there is no presumption of restrictive or expansive interpretation of jurisdictional provisions in treaties. A positive obligation to request termination of domestic proceedings prior to submitting a notice of arbitration imposes an additional and restrictive jurisdictional condition that's not present in the jurisdictional provision. CAFTA Article 1.2.2 provides that the party shall interpret and apply the provisions of this agreement in light of its objectives set out in paragraph 1 and in accordance with applicable rules of international law. The objectives set out in paragraph 1 of CAFTA include creating effective procedures for the resolution of disputes, substantially increasing investment opportunities in the territories of the parties. So these are objectives F and D. Further, the preamble of the CAFTA states that the parties resolve to ensure a predictable commercial framework for business planning and investment. As the Tribunal is well aware, Article 31.1 of the Vienna Convention of the Law of Treaties codifies the well-established guiding principle of treaty interpretation. It's revealing that the respondent, in its written pleadings, does not refer once to principles of treaty interpretation in the Vienna Convention on the Law of Treaties. This is particularly surprising since the entire preliminary objection rests on the interpretation of Article 1018(2). Rather, the respondent asserts that there must be a positive obligation to discontinue under Article 1018(2), since otherwise a waiver is defective or invalid or repudiated or a number of other adjectives. But this is simply not the case. The whole point of the submission of a binding and written waiver is that it's effective, notwithstanding the subsequent conduct of the claimant. The state obtains the benefit of the waiver and can use it to have the domestic proceedings dismissed if the claimant fails to discontinue proceedings or initiates new proceedings. As the claimants submit in paragraph 17 of their rejoinder, the ordinary meaning of Article 1018(2), we have the text in front of us, is that a written waiver must, the notice of arbitration is accompanied by a written waiver. the ordinary meaning of these words cannot be reasonably interpreted as requiring discontinuance of existing proceedings prior to submitting a claim, while simultaneously requiring a written waiver of the right to continue those same proceedings. If this were the case, there would be no reason, there would be no need for the waiver of the right to continue, because there would already have been discontinuance. The respondent's interpretation of the CAFTA text rewrites the requirement to a requirement to discontinue existing proceedings prior to the submission of a claim, and then to waive any right to initiate new proceedings. And our submission is that the ordinary meaning of the text does not support this interpretation. We say that if the CAFTA drafters had intended to make discontinuance of existing proceedings a jurisdictional precondition to submitting a claim, they would have done so expressly through clear language to that effect, while maintaining a requirement for the waiver of rights with respect to the initiation of new claims. Turning to the surrounding context, the fact that Article 10.18.3 states that certain types of action may be continued does not warrant reading in an obligation to discontinue proceedings. Rather, Article 10.18.3 provides an exception to the scope of the required waiver. Paragraph 53 of the decision on jurisdiction in RDC in Guatemala expressly refers to Article 10.18.3 as an exception, and we submit that this interpretation is correct. That what the CAFTA drafters intended by 10.18.3 was to create an exception, a limited exception for the waivers, which of course is really not at issue in this case. If the intent of the CAFTA drafters had been to provide an absolute prohibition on continuation of domestic proceedings as a condition on jurisdiction, Article 10.18.3 would have been read as a prohibition, and it's not. When the CAFTA drafters wanted to prohibit certain types of concurrent proceedings, they did so expressly. This was done, for example, in Article 10.18.4 that says that no claims may be made for breaches of an investment authorization, of an investment agreement, if the claimant has previously submitted the same breach in domestic proceedings. Further, Annex 10E provides that a U.S. investor may not submit a claim to arbitration under CAFTA if the investor had alleged a breach of CAFTA in the domestic courts of a Central American party. So in the other instances, we have an express prohibition. Throughout its written submissions, the respondent states that the claimant's waivers are invalid or defective because the claimants did not request discontinuance of the proceedings prior to submitting a notice of arbitration. The respondent argues that the waivers were invalid the moment they were submitted. At the same time, the respondent appears to agree that as a result of the waivers, the claimants waived rights to the domestic proceedings. Thus, on one hand, the respondent acknowledges that the waivers were effective for the purposes of waiving rights. There was a waiver of legal rights to initiate the proceedings. But on the other hand, the respondent argues that the waivers were not effective for the purposes of complying with CAFTA's jurisdictional requirements. In addition to being inconsistent, the respondent's argument rests on this assumption that in order to be effective, the claimant must do something more. The claimants must request termination. Claimants reject this interpretation of CAFTA. As noted by the Tribunal in Waste Management 2, in reference to waivers under Article 1121 of NAFTA, a waiver is definitive in its effect. A waiver is a unilateral and final abandonment, extinguishment, and abdication of legal rights. It's the very fact that a waiver has this definitive effect that makes it such an effective tool to protect the interests of host states. The respondent argues in his reply at paragraph 32 that if, despite the written waiver, concurrent proceedings in fact exist, the waiver is not effective because it is not achieving its purpose. But the very effectiveness of the waiver is that it provides a final and definitive abandonment of the investor's rights to continue any domestic proceedings, with respect to measures that are also subject to CAFTA claims. The submission of a signed and binding waiver to a respondent state ensures that a state is not required to defend itself in concurrent proceedings. If the respondent's submission is correct, then the corollary must be that CAFTA does not permit, indeed prohibits, concurrent proceedings, since the respondent's argument is that concurrent proceedings make a waiver defective and thus deprives the CAFTA tribunal of jurisdiction. Therefore, there could never be concurrent proceedings because the CAFTA tribunal would never have jurisdiction. In the claimant's submission, CAFTA does not require exclusivity of proceedings as a condition of consent to arbitration, as a jurisdictional condition. The structure of the waiver requirement in Article 1018 means that the state as the beneficiary of the waiver ultimately has some discretion in whether to allow domestic proceedings to continue. We do not say that this is a likely or frequent occurrence. Rather, the point is simply that the existence of concurrent domestic and CAFTA proceedings with respect to the same measure is not impossible. The delivery of the waiver puts the respondent state in the position of having a choice. Although in the vast majority of cases, respondent states will undoubtedly want to have the benefit of the waiver. At the same time, a respondent state may have an interest in certain cases in allowing domestic proceedings to continue to completion. The non-disputing party of submission of the Republic of Costa Rica suggests that the principle of effectiveness in treaty interpretation requires that the treaty be interpreted to impose a positive obligation on a claimant to discontinue any ongoing domestic proceedings. Claimants agree that the principle of effectiveness applies to treaty interpretation. In accordance with Article 31 of the Vienna Convention, treaty interpretation should be interpreted to give effect to the objects and purposes of the treaty, and effect should be given to the treaty text. Treaty provisions and terms should not be interpreted in such a way as to be ineffective or to render them meaningless, redundant, or inutile. Costa Rica's submission, however, I respectfully submit, assumes that a written waiver is not effective. In claimant's submission, it is. It ensures that the state is not forced to defend itself in concurrent proceedings. Further, it appears that Costa Rica's submission addresses post-waiver conduct after the submission. The claimant and the respondent agree, however, that post-waiver conduct is not a jurisdictional issue. Article 1018 sets out the limitations and conditions on the consent to arbitration. The principle of effectiveness is not served by adding additional jurisdictional requirements that are not present in a treaty text. Imposing an additional jurisdictional requirement not evident on the face of the treaty does not create effective procedures for the resolution of disputes, nor does it give effect to the ordinary meaning of the treaty text as agreed between the parties. To complete my submissions on the question of whether the failure to discontinue the domestic proceedings is a jurisdictional impediment, I'd like to briefly address the award in Waste Management 1, the decision in jurisdiction in RDC in Guatemala, and in addition, I'll briefly address the decision on jurisdiction in Vanessa Ventures and Venezuela. First, the claimants submit that the decisions, or the award and the decision in Waste Management and RDC, respectively, are distinguishable on their facts. In both Waste Management 1 and RDC, the tribunals were faced with situations in which there were ongoing domestic proceedings at the time of the issue arose before the tribunal. In the case at hand, the domestic proceedings ended 3 months before this tribunal was constituted, this tribunal being constituted on July 1st. Further, it's clear that there are no currently ongoing proceedings in El Salvador with respect to Commerce or Sansep. The jurisdictional defect in Waste Management 1 was that the investor submitted a waiver with a restrictive scope, a waiver that purported not to apply to non-NAFTA claims, including claims based upon domestic law. As a result, the waiver was defective from the day that it was submitted because it did not satisfy the required rationale materiae scope of the waiver. The Waste Management 1 Tribunal determined that a waiver containing the additional language did not comply with the treaty, pointing to the interpretation that the investor itself gave to the additional language, as evidenced by its conduct. The fact that the investor in that case filed 3 new legal proceedings after tendering its claim. In its award, the tribunal repeatedly refers to the investor's post-waiver conduct in assessing the investor's intention in granting a qualified waiver. The Waste Management Tribunal concluded that, and this is at section 30, based on the foregoing, it is clear that the claimant issued a statement of intent different from that required in a waiver pursuant to NAFTA Article 1121. The waiver was defective from the beginning and also defective for all claims. So the point about the Waste Management 1 sort of applying to the situation here is not applicable, because in the waste management case, you had a defective waiver, a qualified waiver that applied to all claims. The issue here is, to the extent that there's a defect, the non-compliance is allegedly that the domestic proceedings with respect to one measure were not withdrawn. The waiver was defective in waste management from the beginning because of the qualified language, and in the claimant submission, the tribunal rightly found that there was no jurisdiction because the waiver was defective when it was submitted. The Waste Management 1 Tribunal does not stand for the proposition, in our view, that a valid waiver generally is invalidated by subsequent conduct. That's not the issue. That's not the real issue that was in dispute in Waste Management 1. With respect to the decision on jurisdiction in RDC in Guatemala, to the extent that that RDC in Guatemala stands for the principle that the mere existence of concurrent proceedings on the date of submission of a CAFTA claim makes a waiver defective, we respectfully submit that the decision in RDC should not be followed. Although the RDC tribunal found that the defect in the investor's waiver was triggered because the 2 domestic arbitration proceedings existed and overlapped with the CAFTA arbitration, with the greatest respect to the tribunal in RDC, the tribunal does not explain, there's no reasoning on why an overlap necessarily renders an otherwise valid waiver defective, and why that conclusion is mandated by the CAFTA text as interpreted by rules of treaty interpretation. The approach of the tribunal in RDC may be explained by the fact that RDC's argument really focused on the question of whether there was an overlap. Their primary submission was that there wasn't an overlap, therefore there was no issue. Of course, the RDC tribunal then found that there was an overlap and then made the determination that because of the overlap, there was no jurisdiction. In the claimant submission, it's incorrect to analyze concurrent proceedings and overlap sort of as a question of defect in the waiver. Where there's a written waiver, it has definitive effect. The jurisdictional requirement with respect to the CAFTA arbitration is met. The question is then the effect of the waiver in the other proceeding, and whether with respect to the arbitration and then the subsequent question, which I'll be turning to in a moment, is whether sort of bad faith non-compliance with the waiver might render claims inadmissible. The RDC tribunal's focus on the overlap of different proceedings as a jurisdictional test under Article 1018(2) is unpersuasive. In a case where claimants begin domestic proceedings after the initiation of a CAFTA claim, there would be concurrent proceedings, but in that case, a CAFTA tribunal would still presumably have jurisdiction. Indeed, the CAFTA tribunal may have made an affirmative determination, made a decision on jurisdiction. We then have in that case, it's clear that the tribunal has jurisdiction based upon the fundamental principle that events after the submission to arbitration are not relevant to the determination of jurisdiction. simply put, the initiation of proceedings after the submission to arbitration would not be a jurisdictional issue. And the claimant asks, if the initiation of new proceedings is not a jurisdictional issue, why is it that the continuation of existing proceedings is a jurisdictional issue? Different jurisdictional treatment is not justified, and is not justified clearly on the basis, there's no distinction in the clear language of the treaty between the effect of a waiver with respect to continuation versus the effect of a waiver with respect to initiation of new proceedings. This goes back to the claimant's fundamental point that the mere existence of the fact that there were concurrent proceedings does not deny a CAFTA tribunal of jurisdiction, and that there is no positive obligation to discontinue prior to submitting a claim. Finally, I would, just in terms of my submissions on this issue, I'd like to refer to the Vanessa Ventures in Venezuela case, a case under the Canada-Venezuelan Investment Treaty. That treaty, like CAFTA and NAFTA, requires that the investor submit a waiver of the right to initiate or continue other proceedings. Now, in Vanessa, the tribunal dismissed Venezuela's objections to jurisdiction based on noncompliance with the waiver, notwithstanding the fact that at the time the notice of arbitration was submitted, there were at least 10 ongoing domestic proceedings. Now, as the claimant rightly notes, it is true that Vanessa thereafter discontinued those. But at the time of the submission, there were the concurrent proceedings. Further, after the submission of the notice of arbitration, there was a final judgment in one of the cases, just as in this case. Further, Vanessa began a new proceeding seeking extraordinary review of a decision of the Constitutional Chamber. The Constitutional Chamber then subsequently dismissed Venezuela's petition for seeking extraordinary review based upon the waiver, the application of the waiver. In Vanessa, therefore, the tribunal rejected the objection to jurisdiction even though, one, Vanessa did not continue all proceedings before submitting a claim, and two, that there was a final court judgment rendered in one of the proceedings after the submission of the notice of arbitration, similar to this case. Further, the Constitutional Court in that case, in Vanessa, dismissed the extraordinary review proceeding based upon Vanessa's waiver. So again, we have a domestic court, that a state that is a beneficiary of a waiver that uses the waiver to have a proceeding dismissed. The respondent in its reply correctly notes that in Vanessa, the claimants discontinued proceedings after the submission of the notice of arbitration, and that one of the disputes in that case was whether the discontinuance had to be with or without prejudice. That aside, Vanessa Ventures is a clear case where an investment treaty tribunal found that the existence of concurrent proceedings was not fatal to jurisdiction. Further, Vanessa's waiver was not found to be defective, even though it had initiated a new proceeding. Rather, Venezuela was able to rely on Vanessa's written waiver to have the Constitutional Chamber review proceeding initiated by Vanessa dismissed. I'll now turn to unless there are any questions regarding the claimant's submissions on the issue of sort of discontinuance prior to submission of notice of claim, I'll turn to the issue of post-waiver conduct. The claimant's second submission is the fact that the domestic proceedings are continued after the submission of the notice of arbitration is a question of admissibility of claims, not jurisdiction. Although the respondent accepts that jurisdiction is determined as of the date of filing, indeed the respondent notes that I'll highlight paragraph 86 of its reply that as of July 6, 2009, of course we disagree, we say that the date is July 2nd, the parties' legal rights and obligations relevant for the tribunal's determination of its jurisdiction were frozen as a result of the filing. So even though the respondent accepts that jurisdiction is determined as of, in our view, the 2nd of July 2009, the respondent at times also seems to suggest, in particular parts of its reply, that the validity of the waiver also depends upon post-waiver conduct. Our submission is clear that the claimant, that in accordance with established jurisdictional principles, the claimant's post-waiver conduct is simply and cannot be relevant to the question of jurisdiction. Events that take place after the submission of a claim to arbitration do not affect jurisdiction. This, however, does not mean that a claimant's post-waiver conduct is irrelevant and that a respondent state and the tribunal are powerless in the face of the existence of concurrent proceedings. First and foremost, the respondent state is the beneficiary of the investor's waiver, which has definitive effect and which it can use to have domestic proceedings dismissed. And this afternoon, I will return to the point about the procedural question under El Salvadoran law that was discussed this morning about whether it was actually possible for El Salvador to have the pleadings, the domestic proceedings dismissed. In summary, the opinion of the Attorney General clearly states that claimants can request to have proceedings discontinued. And the claimants agree with that. We do not object. We agree that the claimants, it was possible for the claimants to have discontinued the proceedings, even though the issue was before the deliberation of the court. However, the Attorney General's opinion does not say anything about the other question about whether the respondent state under Article 40 could have also requested to have the proceedings discontinued. There's nothing in the Attorney General's opinion on that point. Our submission would be that it is possible under El Salvadoran law for the respondent state to have submitted the waivers. And I guess also in the alternative, if it was impossible, in this case, I mean, clearly this is not a situation where the El Salvador tried to submit the waivers to the court. The court said, well, actually, we can't do that procedurally. And then the respondent said, asked the claimant, well, can you please discontinue? And then there was a refusal by the claimant. That's not the situation. Turning to the main point, the claimants submit that the tribunal has the power to find that a CAFTA claim is inadmissible where there are ongoing current proceedings. Once a tribunal has jurisdiction, then we have the existence of sort of jurisdictional power. The question of admissibility is with respect to sort of is the question of once a tribunal has jurisdiction, the exercise of that power. And as highlighted in the decision in SGS Philippines, international tribunals have a certain flexibility in dealing with questions of competing forms. ICSID tribunals have the power to stay a proceeding or to find that a particular claim is inadmissible until any impediment to the claim has been remedied. A tribunal's supervisory power to find claims inadmissible provides a powerful disincentive from claimants from pursuing concurrent proceedings. It's a control mechanism because claimants will be aware that if they engage in abusive conduct, in bad faith conduct, in the respondent's submission, by starting multiple proceedings in multiple fora, that our submission is clearly that type of abusive conduct can be controlled by a tribunal on the basis of a flagrant sort of and bad faith continuation of proceedings can be sanctioned by the tribunal by finding that those claims are inadmissible.
May I ask a question? On the language of Article 10.18 paragraph 2, is the period between the filing of the notice of arbitration accompanied by the waiver and the date that the Supreme Court rendered its decision, is that caught by the words to continue before any administrative tribunal as set forth in Article 10.18.2 under B.
Mr. President, I'm unable to answer that question at the moment. I'd like to take time to...
But you understand the question, what I'm saying, because the time between the filing of the request for arbitration accompanied by the waiver, which sets forth the language as contained in Article 10.18.2, and the decision by the Supreme Court, that period of time.
Our submission would be that the waiver covers that period of time.
Yeah, so that period that would be caught by those words, to continue before the administrative tribunal. Or any administrative tribunal for that matter, to be correct.
In our submission, yes, although I'd like to reserve the opportunity to provide a fuller submission on that point this afternoon.
Now, could you then also apply then your mind to the following, that is it fair to assume that the claimants knew that the decision would be forthcoming of the Supreme Court?
The claimants, from the claimant's position, the proceedings in the El Salvador after the last claimant, the claimant's last submission in the domestic proceedings appears to have been sometime in 2008. From the claimant's submission position, the proceedings were then essentially a black hole. In the sense that there was nothing happening in those proceedings. The claimants.
Yeah. Okay. Right. Let's be more specific.
Yes.
On the 2nd of July 2009.
Yes.
Your clients filed a notice of arbitration together with a written waiver.
Yes.
And we just established that, but you're subject to what you would like to reflect further on and to come back, that the period between the 2nd of July 2009 and the decision of the Supreme Court on the 29th of April 2010, that period of time is caught by the words continue before any administrative tribunal.
Yes, Mr. President.
All right.
Yes.
On the is then my follow-up question is it fair to assume factually that on the 2nd of July 2009, the date of the filing of the notice of arbitration, your clients knew that at some point in time after the 2nd of July 2009, Supreme Court would render a decision?
The claimants were aware that as stated in the notice of arbitration, that those proceedings were continuing, and yes, at some point that there would, that the matter was, at that point, upon the submission, the claimants were not aware that it was currently in deliberation before the Supreme Court.
Sorry, your clients were not aware on the 2nd of July 2009, is that your submission, that there would be, that the Supreme Court was in the phase of deliberating its decision?
That's correct.
Was there not subsequent a notice that they were in the phase of deliberations?
Not that we're aware of. There's no evidence to that to that effect.
Were your clients totally ignorant of those proceedings before the Supreme Court?
There were
there
were issues of miscommunication with local counsel. There was not a free flow of information. In early 2009, the claimants were not, at the time of submitting the notice of arbitration, knew that the proceedings were continuing, but did not know exactly at what state of those proceedings were at.
And when did they become aware of what the status was of those proceedings? To the extent that you know this.
The claimants became aware of the fact that a judgment had been rendered in July 2010.
Wait a minute. The date of the Supreme Court judgment is which date?
Is the 29th of April is the date of the notification of 2010. That information was not communicated to claimant in United States. There was not.
Two judgments. Now we're talking about two judgments.
Yes, the two judgments.
Okay. Thank you. There we go.
I just want to make sure I understand. You'd used the term black hole before. As I understood the record, the respective disputing parties in the court proceedings filed their pleadings and whatever evidence in accordance with the civil procedure of the respondent. And at a certain point, that pleading phase was completed. And I mean, when you use the term black hole, which is rhetorical,
yes,
not descriptive, I'm trying to understand whether you mean something different than what one would ordinarily expect following legal argument to a court, which is that the court would be deliberating. And that period of time during it takes to deliberate can be very short, or in some cases, it can be very long. It's not a comment about any particular legal system. It's a generally known fact. Do you mean something different than that? That anything other than the court was deliberating?
No, I retract the comment that it was a black hole. I mean, the point was that nothing more than the fact that from the claimant's perspective, they did not know when those proceedings would be resolved, and that the our understanding is that the pleading part of the proceedings was finished.
But simply to confirm, you just stated also that they were aware that the proceedings were continuing before the Supreme Court.
They were. The question is, as of July 2nd, 2009, when the notice of arbitration was submitted, the claimants were aware that the proceedings were continuing. They were not aware that the Attorney General had just in June done their final submissions. That is the position that's put forward by the respondent. That the final step in the litigation completed in June of 2009. That was unknown to the claimants. There's no correlation between the June 2009 date of the completion of the proceedings in El Salvador and the filing date on July 2nd, 2009. The filing date on July 2nd, 2009 was because of the 3-year time limitation issues. And so although the dates, when you put them up against each other, might suggest that there was a reaction based upon the claimants were acting because of the completion of the proceedings, that's actually not the case. And the claimants did not know, knew that the claims were, the proceedings were continuing, but did not know that with respect to the Attorney General's final submissions in June 2009.
Whilst we are in Q&A, may I ask you a question which was just a previous point? It has not to do with where you are now at this point in time. It's about the post-submission of waiver conduct, if I may call it that way. You were discussing Waste Management 1.
Yes.
And if I understand the submissions on your side correctly, You say in, let's see, it is the response in paragraph 43. Perhaps you would like to take it in front of you. You rely on the dissenting opinion of Mr. Hyatt, sorry. Yeah, you see that?
Yes.
May I invite you to take waste management 2? And that's also a question I have for the respondent. So look at this. So that's, you say you rely on this dissenting opinion, and then you go to waste management 2, and please go first to paragraph 19 of waste management 2. You have that in front of you?
Yes.
Yeah. And there they discuss what happened in the first arbitration. And then you see the last sentence of this paragraph. It says the respondent, and this is in this case Mexico, however, stresses Mrs. Hyatt statement that, I quote, the entire NAFTA claim has been undone, unquote. In its view, this indicated much more than a procedural error immediately curable by new proceedings. Yeah, you see that statement?
Yes.
So that's, you rely on the statement of Mr. Hyatt. Then they go on in paragraph 2021, discussing this, 22, and then they come at paragraph 23, and that's where my question is directed at. It says, and I quote now from Wage Management 2, in the present tribunal's view, the dissenting arbitrator's characterization of the effect of the decision cannot be decisive, even if that characterization was clear and unambiguous, between brackets, which it is not, close brackets. Only a majority of the tribunal could determine the effect of its decision, and as noted, there is no indication on the face of the award that the majority expressed any view on the matter. End of the quote. My question to you is, and probably also for the respondent, is what value, if any, has this tribunal to attach to dissenting opinions, especially the dissenting opinion of Mr. Hyatt, on which you rely in paragraph 43 of your response, in light of paragraph 23 on wage management 2? Perhaps you would like to reflect on this.
Yes, thank you.
You are online now.
Thank you.
I get a note.
Although the claimants affirm that this tribunal has the power to find that claims are inadmissible because of the continued existence of concurrent proceedings, we submit that there's no impediment to the admissibility of this, in this case, because domestic proceedings ended before this tribunal was constituted. In this case, there were no concurrent proceedings. Under Arbitration Rule 6, the tribunal was constituted, and the proceedings in this arbitration are deemed to have begun on July 1st, 2010, well over 3 months after the date of the Second Supreme Court judgment on 18th March 2010.
Sorry, may I just understand what that means? Is it your argument that because the domestic proceedings were completed, that the tribunal has jurisdiction over all claims, including the claims relating to the revocation of the environmental permits?
Yes. We submit that there is jurisdiction with respect to all claims because the way. Yes.
And you would say that to the extent that the tribunal, you would say that the question then becomes one of admissibility because of the fact that the domestic proceedings were not discontinued. And do you say that those claims are admissible?
Yes. in our submission, the claims are admissible. Because there's currently no impediment to the tribunal considering those claims. May elaborate me to the. I'll turn to my submissions. The third submission is that the claimants have acted consistently with the waiver since July 2nd, 2009. Respondents charge that the claimants have engaged in manifest violation of an explicit precondition to initiating CAFTA arbitration and have acted in bad faith, and that their conduct is an affront to the international arbitration process. These allegations are frivolous and not worthy of serious attention. What is the evidence of claimants' bad faith? In its reply at paragraphs 128 to 132, the respondent points to a delay in constituting this tribunal, some factual errors in the notice of arbitration, and of course the failure to discontinue the domestic proceedings. The revocation of the environmental permits and the respondent's other measures have destroyed the claimants' business in El Salvador and prevent the claimants from benefiting from their investments. The claimants worked hard to address the legal and logistical and financial challenges resulting from the measures. The claimants prepared their waivers with careful attention to CAFTA requirements and did exactly what CAFTA Article 1018(2) says that they should do. Claimants did not commence any new litigation and took no action in the domestic proceedings. Shortly after the submission of their notice of arbitration, the Attorney General of El Salvador sent a letter to the Secretary General of ICSID. And in the Attorney General's letter of 14th August 2008, the Attorney General asked the Secretary General to find that there was the claims were manifestly outside the jurisdiction because the claimants' waivers were defective. The Attorney General's letter then states that even if the claimants were to withdraw the legal proceedings still pending in El Salvador, claimants' failure to honor their waivers before submitting the request for arbitration to ICSID cannot be remedied once the request has been filed. The letter made it clear that the Attorney General's position was that the waivers were defective, the defects could not be remedied, and that formally discontinuing the domestic proceedings would have no effect on ICSID jurisdiction. The fact that the claimants took no action to formally discontinue the domestic proceedings is entirely consistent with the Attorney General's position that any such action would be pointless. Further, it must be noted that the Republic of El Salvador never, at any point, requested that the claimant take the formal step to discontinue the domestic proceedings. Rather, El Salvador's position was that the CAFTA arbitration should be discontinued. The respondent refers in its reply to the Attorney General's communication of August 18, 2009 to the court regarding the status of the proceedings. Despite having complained of the concurrent proceedings 4 days earlier in the letter to ICSID, it does not appear that the Attorney General brought the waivers to the attention of the court in August 2009 or thereafter, including when the Attorney General received the court notification on October 1, 2009. El Salvador suggests that the claimants should have responded to this notification from the court, but the notification is clearly addressed to the Attorney General, and it's, in any event, it's sort of unclear why local counsel, given that it was a notice to the Attorney General, why there was no reason for local counsel to respond to that notice from the court. Respondent also refers to a letter from El Salvador's lawyer, Attorney Pedro Valle, in December 2009 to Marne to suggest that claimants were awaiting the domestic proceedings. The letter, in fact, suggests quite the opposite. Attorney General Pedro Valle explains that due to the domestic proceedings challenging the revocation of the environmental permits, that Commerce had not complied with various requirements established in the resolution for the closure of the San Cristobal plant. He then says that the company was closing the facility. In paragraph 4, he says that compliance with the measures established by the ministry in reference to its resolution dated July 5th, 2006 will begin. Commerce thus was complying with the very same resolutions that were the subject of the domestic proceedings. Contrary to the respondents' view of the claimants waiting for a favorable result overturning the resolutions, in December 2009, the claimants were actually complying with the requirements for the closure of facilities required with Marne resolutions. This demonstrates that the claimants were in fact complying with the Challenge Act, conduct completely at odds with the respondents' allegations that the claimants were awaiting a favorable result in the domestic litigation. This allegation is completely fanciful. Having delivered the waivers in good faith, there was no need to take the formal step of discontinuing the proceedings, a step that the Attorney General had in any event informed them was pointless. Finally, claimants note that the respondent has suffered no prejudice by the conclusion of the domestic proceedings in its favor. Indeed, the respondent relies upon the court decisions to suggest that the revocation of the environmental permits were justified and legal under El Salvadoran law. Of course, what's at issue in the CAFTA claim is whether there was a breach of the CAFTA obligations, not whether there was a breach of El Salvadoran administrative code. And if the claimants had obtained a favorable result in the domestic proceedings, respondents would now undoubtedly be arguing that the waivers were effective to waive any rights in those proceedings, and that a waiver of rights to initiate and that there would be also a waiver of any rights to initiate any enforcement action to obtain the benefit of this fanciful favorable result. The point with the claimant's submission with respect to the definitive effect of the waivers is that after the claimant submitted the waivers, there was not going to be a favorable result, whatever happened. The waivers ended any expectation or right to benefit from the domestic proceedings. Mr. President, I am aware of the time. Perhaps could I, according to my watch, I have 4 more minutes? I'm just asking for clarification on the amount of time.
You're right on your watch, and there's also another right, but there's a human right to food.
Yes.
And let's see how we can deal with this. How you still of your slide 52, and there's still slide 59. Let's see.
Mr. What I would propose doing would be to make the submission just on point 4 with respect to the preliminary objection cannot result in the dismissal of the claimant's CAFTA claims, the RDC overlap issue, which should take about 5 minutes. And then my submissions with respect to San Sebastian and then foreign investment law claim can really be wrapped into the claimant's response this afternoon, and we can be responsive to the respondent's arguments this morning on those further submissions.
Is that fine for the respondent? Okay. Please proceed, but really stop at 1:45. You may do it.
Thank you very much, Mr. President. My fourth submission addresses the point that the respondent's preliminary objection cannot result in the dismissal of all the claimant's CAFTA claims. The question for the tribunal to decide is this. If the tribunal were to find that the failure to discontinue the domestic proceedings creates a jurisdictional impediment, does this affect El Salvador's consent to the entire CAFTA arbitration, or is its consent to arbitrate claims relating, or does it affect El Salvador's consent to the entire CAFTA arbitration, or only its consent to arbitrate claims relating to the revocation of the environmental permits. Claimants submit that any jurisdictional defect that the tribunal finds applies only to the claims with respect to the respondent's revocation of the environmental permits. The claimants submit that the general approach of the tribunal in RDC in Guatemala should be followed on this issue, and any defect in consent only applies to the extent of the overlap of the measures at issue in the CAFTA and other proceedings. As stated by the RDC tribunal, the word claim in Article 1018 means the specific claim and not the whole arbitration in which the claim is maintained. The interpretive issue is whether the word claim in Article 1018.2, no claim may be submitted to arbitration, means the entire arbitration proceeding, or whether a claim submitted to arbitration may contain multiple claims such that each claim is to be considered separately as a claim subject to the provisions of Article 1018.2. In RDC, the tribunal noted that Article 1018.1 time bars claims older than 3 years from the date on which the claimant first acquired knowledge of the alleged breach. Here, the word claim must mean each individual claim submitted to arbitration, because the time limit runs from the date of each individual measure that is alleged to breach CAFTA. The RDC tribunal rightly notes that there's no good reason why the same word in 1018.2 would have a different meaning. As the RDC tribunal also notes, the reference to claim in 1018.4 is to a specific type of claim. And further, Article 1016.2 clearly indicates that a claim to arbitration can include a number of different claims for breaches of various provisions of CAFTA. Article 16.2b and c require information for each claim. Respondents' interpretation of no claim may be submitted to arbitration and Article 1018.2 is excessively restrictive. Consent to arbitration is not a binary choice between consent to all claims and consent to no claims. Each claim must be assessed on its merits with respect to various jurisdictional requirements imposed by the treaty, whether they be temporal requirements, subject matter requirements, or with respect to the submission of a waiver. Claimants make claims of breaches of CAFTA and the foreign investment law based on a number of measures other than the revocation of the environmental permits, including respondents' conduct with respect to the extension of the exploration licenses, the de facto moratorium, and other measures. The respondent itself acknowledges that the resolutions revoking the environmental measures do not constitute all the claims in this arbitration. Dismissing an entire arbitration and all claims based on a partial overlap is not consistent with the objective of CAFTA to introduce effective procedures of dispute settlement. And as rightly noted by the tribunal and RDC, this is a rather ineffective and procedurally inefficient result. The de facto moratorium is a continuing measure. El Salvador is not issuing any regulatory approvals for metallic mining. So notwithstanding the question of the revocation of the environmental permits, there is an ongoing de facto moratorium on mining. Dismissal of the entire arbitration, dismissal of all the claims based upon the waiver issue, would simply result in the claimants resubmitting the CAFTA claims based upon the de facto moratorium and other measures. A procedurally inefficient result, and not one dictated by the clear text of NAFTA as affirmed by the tribunal in RDC and Guatemala, which correctly decided this issue. With that, I will complete my submissions and continue in the afternoon.
But you will do that during the time of the rebuttal?
Yes, yes. Within the 1 hour. I understand that we'll have the 1 hour.
I would like to make one thing clear is if there is something which has not yet been raised and to which the respondent would like to reply, then I would there's liberty to apply on the side of the respondent. Otherwise, you get an uneven, unbalanced proceedings. Yep. Okay, then we will now adjourn for lunch. It's until 3:15.